had a car accident? What you should know about civil court trials. If you were involved in a car accident and your lawsuit has gone through the pre-trial stage, you may be faced with a trial. This is especially so if no settlement has been agreed upon. Although car accident cases rarely go to trial, it does happen from time to time. So let's take a look at what is involved in a civil court trial. The jury selection. Jury selection will begin and all potential jurors are sworn in. The judge will tell the jury what the case is about and the selection of jury members will take place. It is likely that the jurors will be informed of who you are. At this stage, the potential jurors are asked questions. This stage is known as voir dire, and the judge is the one asking the questions. The questions the jurors are asked are typically based on any issues that the lawyers for each side, the plaintiff's and the defendant's side. If at this stage it is found that a juror is unable to be fair, they will be excused. Using the information that the judge has learned through voir dire, and through the information that they have about each of the jurors, your lawyer can excuse, or strike, some jurors for no reason. Your lawyer does not have to tell the court why he or she chose to excuse the potential juror. The number of jurors and the deliberation. In some parts of the United States, there can be as many as 12 jurors, whereas other parts have fewer jurors. If it is likely that your case will last more than a day, the judge may swap a few jurors around. The new jurors will hear the evidence and they will replace a juror who is not able to complete the case. The jury deliberates once the case has ended, but before they deliberate, any unneeded juror is then excused. If your case is not heard by a jury, cases such as these are known as bench trials. Jury selection will not take place. The opening statements. During the opening statements, the lawyer who is representing the plaintiff will speak first. Once the plaintiff's lawyer has spoken, the defendant's lawyer will speak. Many defense lawyers choose to make an opening statement at the start of the trial, although they are free to wait until the plaintiff's lawyer has spoken. Opening statements help jurors to understand what the evidence for the case may be, from the lawyer's point of view, that is. The evidence. The evidence is made up of witness testimonies and exhibits. Once the testimonies have been given, the witness will then be cross-examined. The lawyer who called the witness asks questions first. Once the witness has been asked all of the lawyer's questions, the other lawyer takes over. Once the second lawyer has finished asking the witness questions, the first lawyer can then raise any issues and ask more questions. Once the juror has finished answering these questions, the second lawyer then gets the opportunity to ask even more questions should they have any. The exhibits. While witnesses are testifying, they may be shown evidence such as documents and photographs. At this stage, if the lawyer who wishes the exhibit to be used as evidence, that can be considered by the jury. This evidence can be used unless the other lawyer decides to oppose it, and if the judge opposes it, then the evidence will not be used. Once all of the witnesses have been called and all of the exhibits have been introduced, it will be time for the plaintiff to rest. If it is decided that the plaintiff has not proven their case, the trial will come to an end and the plaintiff will lose the trial. It will then be time for the defense's lawyer to call the witnesses and introduce any exhibits they may have. If it is decided that the defendant F has not proven their case, the trial will come to an end and the defendant will lose the trial. Once the defendant has finished their case, the plaintiff is then able to present evidence that contradicts the defense. The jury's instructions. Once the judge has seen all of the evidence, they will tell the jurors about the law that applies to this specific case. The jurors are instructed to accept the law and reach a conclusion about the car accident case. The closing arguments. In most parts of the United States, the lawyer's closing arguments will be heard before the instructions that are given by the judge to the jury. In some states, the closing arguments are heard first. The very first argument is made by the plaintiff's lawyer, and it is then up to the defense lawyer to make theirs. Once both sides have made their argument, the plaintiff's lawyer will speak, as it is up to the plaintiff to prove their case. If the plaintiff is unable to prove their case, they will lose. This is why their lawyer has the opportunity to argue before the defendant's lawyer and after. The jury's deliberations. Once all the arguments have been given, the judge will explain how the deliberations should take place. The jurors will then make their way to the jury deliberation room so they can decide on the case. In most parts of the United States, the jury's decision needs to be unanimous.